Hello and welcome to the classes of the company law. We are in the unit 4 of a company law. In this lecture, we will learn about the management and control of the companies. Since company is a legal entity, it is a legal person, but it do not has a human face. So company cannot act on itself. So, on behalf of a company, some persons are authorized to act under the provisions of the Companies Act of 2013. One of the key portfolio under the Companies Act is the director and another is the company secretary. So in this unit we are going to learn about the provisions of the director and the company secretary in the Companies Act 2013. Director is a human being, an individual who is appointed by the shareholders to manage and oversee the operations of a company. So the director is automatically a executive head of the company in the Companies Act of 2013. Director can be of some types. There can be executive director who is involved in day-to-day operations. He is well versed in the day-to-day operation of the industry. Another type of director is the non-executive directors. These type of directors provide only guidance and they are not involved in the daily management of the industry. Another such type of director is the independent director. Independent director has to be independent from the promoters and the team of management, and he should act unbiased and he should use his discretionary powers on himself. So, in the Companies Act 2013, there has been specific provision regarding the members in the companies and the number of director in a company. It is not mentioned here, but in the Companies Act 2013, it has been stated that there should be minimum one number of director in the one person company and minimum two number of directors are necessary to be appointed in the private company and minimum three number of directors are mandatory to be appointed in the public company under the Companies Act. So, since the appointment of director has been mandatory under the Companies Act, why? What is the objective or the importance of appointment of a director? Appointing the director, it means uh, the director can ensure the good governance of the company. A director can complies with the rules and regulations of the company law, and the company's long-term success depends on the director. So the objective of the director is to outline the processing requirement and legal aspect of a director in the company. To be appointed as a director, what are the mandatory qualifications which you need? So then only you can be appointed as a director. There is eligibility criteria, and this eligibility is are specific. First, eligibility is the age. The director who has to be appointed must have to be at least 18 years of age, which means the director has to be measured in the age. Director should not be disqualified under the Companies Act, uh, and the provisions in the Companies Act regarding the disqualification are that the director is bankrupt or the insolvent and uh, director has committed any offense of the moral turpitude. So these are the disqualifications for a director. Since director is a key portfolio in the company, so the skill and experience of a director is most important for a successful running of a company. Some relevant skills and experiences may be that the expertise or the knowledge of a director in the industry, in the company, the decision making abilities of a director in the leadership are the key skills and the experience which are needed to be appointed as a director. Director should have a person of integrity and commitment towards the company's mission and values. So as we discussed, there are types of directors: executive directors who is involved in day-to-day operations, non-executive directors he only provides the guidance, independent directors they are also not involved in the day-to-day operations, uh, and they are also not affiliated with the company, and they are the independent unbiased decision making persons. There is a provision of a nominee director uh, in the Companies Act 2013, and there is a provision regarding the appointment of a woman director. It has been enacted in the act that there should be minimum one number of women director should be appointed in a company. The maximum limit to appoint a number of director in a company is 15. No company can appoint more than 15 number of director in a company. If a company has to appoint more than 15 number of director, then the company has to pass a special resolution. Then only the company can appoint more than 15 number of directors. In the Companies Act 2013, it has been made mandatory to appoint a woman director in the board of directors. Nominee director is a director appointed to represent the shareholder uh, class of a shareholder. There will be elected director which will be chosen from the small shareholders. The small shareholders means the investors who has invested rupees 20,000 or less. So the process of appointing a director uh, is, firstly, the board has to pass a resolution, a proposal in the board by the board, and there should be approval by the board. Shareholder must approve the proposal of a board, and then it is mandatory to file with the regulatory authority, that is the registrar of the company. Then the company will issue a formal letter or agreement, and, and that agreement will outline the role and responsibilities of the director. There are multiple of provisions regarding the director, how they will work under the Companies Act. So there are legal and regulatory requirements, which is uh, which is one of the unique provisions, such as the director identification number. It has been mandated that if anyone has to be appointed as a director, he should get the director unique identification number by applying to the registrar of the companies. And there is a specific procedure to apply for a DIN, that is director identification number. The director has to be presented uh, in the annual general meeting. The director can call the board meeting. These are some of the powers vested in the director. Term of appointment. Director can be appointed for a term of 1 year or 3 year, and he can also be re-elected. There is no bar on the re-election of the or the reappointment of the director. Director can be removed by the voting of a shareholders in a board decision. Rights and responsibilities of a director. It is a right of a director to receive all the information about the company, as he is a titular head of the company. Right to attend the board meeting and vote on important matter. It is a right of a director. Director also has one more right, which is to indemnify against liabilities arising from the duties of the director. Directors' remuneration and benefits. Directors may be compensated through the salary or by the bonus, or company can give the stocks to the director or any other type of incentives that the both director and the company agrees. There are some challenges in appointing a director, and which can be to in the terms of independent director. When the independent director has to be appointed, it is a challenge to ensure that a director is independent, especially he will not make partial decisions. Other challenges in appointing a director is that director may not comply with the government standards, that the director can have a conflict of interest. These are the some challenges in appointing a director. Resignation of a director. Resignation means the voluntary stepping down from the position of a director in the board of directors. And a person can resign because of his health issues, because of uh, conflict of interests, and maybe because of the pursuit of the professional opportunities. So there can be many reasons on which the director can resign from the post of director. There are legal considerations in resignation of a director. In this, the provision of the article of association and the relevant company laws has to be followed, and there is no liability for resignation. And the director cannot be held liable to be resigned. Director's responsibilities upon resignation uh, limits to those works only which he has done when the time he held the position of a director. The investigation or the pending legal matters during the period he has held the position of a director, for that period only the director is liable for the civil and criminal liability. Removal of a director. When a company has to forcefully remove a director or to step down from the position, then it is called a removal of a director. Removal can be because of the many reasons, because of the fiduciary breach of duties or misconduct, because of the conflict of interest, maybe because of the health problems, he is not able to work efficiently. Director is in failure to adhere to corporate government standards, then the director can be removed. There is a process of removal of a director, and the process is of 6 points. First, the board has to pass a resolution, then shareholder also have to pass a resolution, then the notice for the meeting will be issued, and the voting right will be done. After the voting process, filing with the authorities, that is the registrar of the Companies Act, and then the public disclosure makes a final stamp on the removal of a director. Loan to director. In the section 185 of the Companies Act, it has been barred that company should not provide loan or any such uh, type of credit to the director, but it has certain exceptions, certain purposes for which the company can finance the need, the assistance to provide assistance to the director. Conditions in which uh, loans can be granted to the directors: when the shareholders approve the resolution, board also approves the resolution, and the terms and conditions are specified, that what should be the interest rate, and how to avoid potential conflicts. There should be specified terms regarding the repayment of a loan, including the installment amount, schedule, and duration. Director also has to provide for a security, which means a guarantor. Powers of a director. There are a vast power of a director as provided under the Companies Act of 2013. The director has a power to outline the company's internal rules under the article of association. The director also has a discretionary power and the liability under the statutory laws. And these type of powers are the executive powers, the delegated powers, decision making powers, and authority to act on behalf of the company. Power to manage finances are the powers of a director. So director has a power vested under the article of association, and the key powers which director held is the power to appoint and remove senior management such as CEOs, CFOs. Director has a power to approve major transactions regarding mergers and acquisitions, joint ventures, or sale of assets. Director has a power to make corporate policies. Director has a power to control corporate resources. Director has a power to call board meeting. It is a duty of a director to call board meeting and conduct annual general meeting every year. Duties of a director are binding in nature, and it is a duty of a director to take due care during the working of a company. It is a duty of a director to be loyal towards the company and obedience regarding the article of association and memorandum of association and all the powers which has been vested with the director. It is also a duty to act in good faith for the better earning of a company. It is also a duty of a director to disclose interests. There are fiduciary duties of a director, which means director has to maintain silence and the personal uh, information or the sensitive confidential information has to be disclosed by the director. So it is a duty of a director to maintain the confidentiality and to avoid conflict of interest and to protect company assets. So these are the fiduciary duties depend on the directors. There are some specific legal duties of directors also which are to compliance with the corporate law. So the director who are appointed in the board of directors in the company law, so the director must have a corporate law knowledge, then only he can ensure that the company complies with all the relevant legal laws. So the director is generally expert in the tax laws, employment laws, environmental laws, or in the field of commerce, taxation, and the management. Corporate governance is one of the specific duties which the director has to perform, and they has to be ethically conducted. Financial reporting and disclosure and timely disclosure of financial statements are vested in the directors. The risk management, uh, the director is responsible for identifying, managing, and mitigating risk factors. So the risk management is vested in the is the power of the director under the Companies Act. In the Companies Act, there are many key portfolios such as directors, company secretary, legal advisor, company accountant. So another provision which we are going to read in broad is the company secretary. The company secretary is an officer of the company who is responsible to oversee the governance, compliance with the laws and regulation, and uh, He should be a liaising officer between the board of directors, shareholders, and regulatory bodies. And the company secretary plays a pivotal role in ensuring that companies' actions comply with the all legal regulatory frameworks and safeguards the company's corporate integrity. Company secretary is appointed when he is eligible under the criteria that he should be a member of the institute of the company secretary, that he should be a qualified CS, that is a company secretary examination. He must have qualified the company secretary examination. Board The board of director must approve the appointment of a company secretary, and the notification regarding the appointment of company secretary eh, must be notified. Company secretary can be reappointed when his term expires. And the power of company secretary are to comply with the legal regulatory frameworks of the company law, SEBI, and all other relevant laws. Power of a company secretary is to support the board of directors to maintain the corporate records. Uh, some company secretary has a signatory powers while issuing share certificate, etc. Company secretary also has advisory role to give uh, the advice to the board on the matters related to corporate governance, compliance, and the best practices. One of the power of a company secretary is the liaison role. The company secretary serves a key liaison roles between the company and its shareholders, regulators, and other stakeholders. So these are the specific duties: corporate filing and reports, preparing board meetings and shareholder meeting, secretarial audit, managing shareholder relationships are the specific duty of the company secretary. So company secretary also plays a critical role in the corporate governance. As we have studied, the company is a legal body. It does not have any face. So the company is run by the authorities under this Companies Act, and these authorities are board of directors, shareholders, company secretary, and they are responsible for their acts. So this is all about the management and control of the companies. We have learned in this unit about the directors, their appointment, reappointment, resignation, and removal. We have also learned about the role and responsibilities of a director, and we have learned the appointment, reappointment, power, and duties regarding the company secretary in the Companies Act. This was all in this unit. Thank you so much. Have a nice day.